committed to the High Court for trial prior to the committal. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't constitute the jurisdiction of this honorable court. So we're going ahead with the mandatory thing. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of the law. Would like to ask this honorable court, your worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was couched this way in section 76. Why this particular provision was couched? To stamp out persecution, impunity. It was intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution were arrived to that fact that the state may exceed what is actually within the limit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit. The reason there was that limit of 180 days, and the court was given those powers that these, once the state has failed to take steps to commit the accused persons within 180 days, first appearance before you as a magistrate. Don't do any other thing. Please just consider releasing the accused persons. And that's what we are asking for your worship. This honorable court student agrees of the unaccomplices in the persecution of the accused person by the state. So the only thing that should be done at this stage is to release the accused persons on such conditions you will be moved forward. We do so, your worship.
Your worship, if I may add, just for emphasis, your worship, again, Article 23(5)(c), the command of the Constitution, it says shall, therefore does away with the ordinary bail application which is made that allows for a discretion. So it is a constitutional command. What the court ought to satisfy itself is that the offense is triable only by the High Court, and that the persons who is the applicant have been on remand for more than 180 days before commitment. So I join issue with my senior colleague, Mr. Lukwago, that the committal per se does not take back time to nullify the 180 days. The 180 days are a constant. 2, your worship, is that the 180 days referred to in the constitutional command do not start to run from the date when the applicant is arraigned in the court before which the application is made. I'm saying that the 180 days, upon which bail becomes mandatory, are not counted from the date when the applicant or the accused person was arraigned before court, before which the application is made. and mindful of the decision of the Supreme Court, the Supreme Court directed a transfer of the fines. What I'm trying to say, Your Worship, is that the process from the court-martial to this court is continuous. There is no break so that the proceedings before the Court of Appeal, or the court-martial, are not taken into consideration. So when we speak to the 180 days, Your Worship, the court must take into consideration the date of remand by the General Court-Martial, because it is also a court under the Constitution. So that article, Your Worship, again for emphasis, says in case a person has been remanded in custody. It doesn't say, it envisages that a remand can be made by any court of law, or any court as established by law, of which the General Court-Martial is just one of them. So the argument that may arise from the prosecution that the proceedings in or before this court did not commence or commence this year, and therefore they are not 180 days, does not hold. Court takes into consideration the time when the remand started to run, count the 180 days. And Your Worship, there is a view that perhaps in matters or offenses tried only by the High Court, the Magistrates' Court should not grant bail because the matter is tried by the High Court only. Your Worship, in the current constitutional dispensation, the Magistrates' Court is empowered to grant mandatory bail. Your Worship, it's a common fact that the Constitution applicable in Uganda was promulgated in 1995, so that decisions made thereafter bear in mind the constitutional order of the day. Your Worship, in Uganda versus Tesimana Rosemary, the Honorable Mr. Justice FMS Egonantende, as he then was, Tesimana Rosemary, its criminal revision cause number MSK hyphen 00 hyphen CR hyphen CV hyphen 0013 of 1999. I cite it because it is the current dispensation. Because in that case again, Your Worship, the magistrate had declined to exercise powers and sent the file up for revision on the ground that the matter was tried by the High Court. Your Worship, I beg to read, and I'll avail a copy, what the Honorable Justice Egonantende said. My Lord, it is the, Your Worship, it's the highlight at page 13. So before I take leave of this case, I must say that courts cannot escape blame for this unhappy state of affairs in the criminal justice system, which has no remorse for caging up people in penal institutions for unjustifiable periods of time. It appears that magistrates' courts to which accused persons are first produced before committal regard themselves as no more than, should not regard themselves as no more than assembly line or conveyor belts run by the prosecution. For years on end, the court is content to record endlessly adjournments, etc. But the point that my lord, the judge said at paragraph 39, that even though a magistrate's court has no jurisdiction to try capital offences, accused persons such charges are brought before it to ensure that, among other things, the accused's rights are protected. The courts must be vigilant in doing so by consistently requiring the prosecution to provide information regarding the investigation. What we are pointing out here is that the constitutional command says that once the accused person is emphasizing their rights, once the matter is before it, even for capital offenses, this court cannot feign not to have jurisdiction on ground that the offense is of a capital nature. In Article 23C, therefore, the accused persons contend that they have been on remand by order of the court so established under the Constitution, the GCM, for a period exceeding 180 days. If I count well, Your Worship, today there should be 196 or thereabout. And that the matter which is before this court now is because the accused persons are exercising their right to mandatory bail as commanded by the Constitution. The onus of the court is, upon being satisfied that the 180 days on remand have elapsed, is, as the provision says, that that person shall be released on bail on such conditions that the court considers. Your Worship, we are mindful of the fact, and we are told before, that there are practice directions regarding bail applications, or bail for that matter, in magistrates' courts, which were handed down by the principal judge in regard to capital offences. Your Worship, those practice directions are not in respect to mandatory bail. They are in respect to what I would say, for want of another description, ordinary bail, or bail in ordinary circumstances. In this case, the reason why the Constitution makes a specific command is that the state is expected to have wound up its investigations and made a committal in 180 days. In any event, Your Worship, the practice directions of the principal judge and even the Chief Justice cannot override the express provisions of the Constitution. We just wish to remind the court, and we are aware that the court is already aware, that the Constitution the supreme law of the land. Your Worship, Article 2 of the Constitution is clear. Under the subheading Supremacy of the Constitution, states that the Constitution is the supreme law of Uganda and shall have binding force on all authorities and persons throughout Uganda. So, Your Worship, that means that the Constitution and its provisions have binding force on this court, on the persons of the Chief Justice and the Principal Judge, ordinarily in their individual capacity, and also in their official capacity, exercising their powers as the Chief Justice and the Principal Judge, respectively. So much so that the practice directions they pass must be brought in conformity with the Constitution. They cannot surpass or override the power in Article 23, which my land colleague, Mr. Lukwago, area senior counsel, referred to. We reiterate the prayer that 180 days have elapsed, and as the defense, we shall happily receive the conditions for the mandatory bail, because it is a command that it must be granted.
One of my colleagues will submit an authority. After me, then senior counsel will close our presentation in this application. But I want to start with or just emphasize the practical matters. The date of remand and custody was 20th November 2024, via General Court Martial, criminal case number UPDF stroke GCM stroke 040 stroke 2024. The state is aware of this fact because they have said so. In an affidavit before this honorable court, the state, through its detective IP or Benedict, they acknowledge that the respondents, namely the accused, were previously charged before the General Court Martial at Machinde. The application was filed on 5th March 2025, and it is the application for accessing the court records. Yes, the telephone particulars, which your honor is on this honorable court's record.
I think your worship, maybe just to interject a bit. Allow me to.
I have not said the word and you're panicking.
Just speak.
Yes, you can't stop me before I've said the thing. Relax.
I hope you don't commit another one.
No, it's fine.
So what I'm saying is that the document which my brother is referring to has not been executed yet. And therefore, it cannot form part of the record. We cannot preempt a document in an application which has not been had, and you use it as evidence in your application.
Let him finish his submission so he can make a decision.
Your Honor, before I was rudely interrupted by the representative of the government of Uganda, I was going to draw your attention to, among others, in this very court, criminal miscellaneous application number 001 of 2025, which the
Number?
number 01 of 2025, in which the state made reliance to the affidavit of Detective IP Odiek Benedict, who saw that he's aware not only that the accused were charged before the General Court Martial, but that he's also one of the people who are charged with investigating their matters. That is the date of custody or remand in accordance with the Constitution. Your Honor, the plea for mandatory bail that my comrades have emphasized pursuant to Article 23, Clause 6, Paragraph C, is intended, among others, to ensure that the accused get a fair hearing. The only way people can effectively defend themselves who have spent 6 months on remand is when they have liberty to defend themselves from home, and also to ensure that their trial and detention is not too lengthy. Your duty as this honorable court is partly adumbrated by Article 20 of the Constitution. Clause 1 of Article 20 of the Constitution reminds us that the right to liberty is inherent. It's not a gift of the state. Clause 2 of that article is the effect that this court, the office of the Director of Public Prosecution, and other people should not only respect and uphold the right to liberty and other fundamental rights, but also promote them. What we do here this morning should be seen to promote the liberty of Besigye, Obied, and Dennis. It should not be seen as to frustrate their liberty. And should the state get wayward and try to frustrate that liberty, it behoves you as the judicial officer presiding over this matter under that article to rein in the state and and ensure that it's back on the track, the constitutional track of guaranteeing that liberty. These provisions of the Constitution are very important because the Constitution is supreme. The supremacy of the Constitution is underscored by Article 2, Clauses 1, 2, and 3 of the Constitution. So any other speech, any other law that tends to negate the constitutional entitlement to liberty after 6 months should be seen as inconsequential to the extent of that. And I say this in anticipation of some speech that may come after here relating to some practice directions, which are in fact a challenge of the are being challenged before the Constitutional Court. But even those guidelines themselves acknowledge that the Constitution comes first. At this juncture, my land brother who wanted to give us an authority should give us, then our closure will come through.
Most obliged, Your Worship. Your Worship, for purposes of record, I am to know. Your Worship, I want to join issue with my learned brothers who have submitted on the powers of this court to grant accused persons mandatory bail, but only to add an authority for when court takes a view that the authority that was submitted is of an earlier date. Your Worship, I have much of that. For if court takes a view that the authority that was submitted is of an earlier date, Your Worship, formally in 2022, the Honorable Justice Yaruhanga Jesse, sitting at Masindi in the High Court, in Nyangoma Flavia versus Uganda, Nyangoma Flavia versus Uganda, in criminal application number 7 of 2022, at page 3, paragraph 4, I had the opportunity to say this, and I will quote in verbatim. I have perused the lower court file copies of the lower court copies of the remand warrants and the applicants and 7 others. The remand warrants are to the effect that the accused persons were remanded first in prison on 12 November 2021, save for Kato Francis, A8, who was released on bail on account of being a juvenile. Since 12 November 2021, when the applicant and the 7 others were first remanded to prison, more than 180 days passed before the committal to the High Court. It follows, therefore, that neither the magistrate's court nor the court that has neither the magistrate's court nor this court has any discretion not to grant them bail. It was a violation of Article 23, Clause 6, Subclause C of the Constitution as amended for the magistrate before whom the accused persons first appeared after the expiration of the 180 days remand period to decline or refuse to release the accused persons on bail, for he or she had no discretion to do so. Your Worship, if I may add, is that such a decision of the High Court has a binding authority nature on this specific court. Your Worship, the Honorable Justice Jesse Yaruhanga took a view that the magistrate does not have discretion to deny an accused person who has appeared before him or her after the lapse of 180 days. For avoidance of doubt, Your Worship, the accused persons were charged with murder, which is a capital offense and only triable by the High Court. Your Worship, my comfort in that authority is to the extent that this decision is of similar nature as the case we are faced with today. And therefore, I reiterate in the area of prayers of my learned brothers that the accused persons are entitled to be released, and keyword entitled to be released on mandatory bail by this court. And this court has no discretion to deny such an application. Much obliged, Your Worship.
But before I canvass my 2 points, I just want to tell my learned friend, the prosecutor, that it is unfortunate that he would refer to the previous incarceration of Aaron, whether in jest, knowing very well that it was before a lay court, because he said that he may once again be convicted. Yes, I was just expressing regret that my friend would, my learned friend would joke with liberty of a colleague taken away illegally, as the Supreme Court found. But having said that, I want to commend my team. They have demonstrated to your honor the law on bail and the fact that the court has no discretion whatsoever. But we also want to refer you to one more case from the Supreme Court in the Foundation for Human Rights Initiative versus the Attorney General and the Solicitor General, Constitutional Appeal number 3 of 2009.
Yes, repeat the case.
Foundation for Human Rights Initiative versus the AG and SC. Constitutional Appeal number 3 of 2009. The decision is by Katurebe CJ, as he then was. He held that when an accused person applies for bail, the court retains the discretion whether or not to grant bail to the accused person, which discretion has to be exercised judicially. But now comes the most important. The only time when the court has no discretion is when a person has been on remand for the period stipulated in Article 23(6)(b) or 23(6)(c). In those situations, the court shall grant bail. I suppose the court retains the power to determine the terms of the bail. In other words, this is a Supreme Court decision, and this honorable court is obliged to follow not just the High Court, but the Apex Court decision. Now my 2 points. I want to refer you to the obvious 26 of the Constitution of Uganda, which clearly states that judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with values, norms, and aspirations of the people. In other words, the framers of the Constitution and the people of Uganda put the trust in judiciary to adjudicate on these matters. I am therefore urging your honor in exercising your judicial power and in giving the ruling in this bail application to abide by the values of constitutionalism and the rule of law, and in the name of the people of Uganda, grant our clients bail. My learned friend will be submitting on the 3rd on April, but they have a similar history of detention, not exact the same period, but anybody who has finished more than 180 days, you are obliged to release them pending their committal. I'm also reminding the court of the obvious that the scales of justice must balance, And in Article 21, equality and freedom from discrimination, we come before you as parties with equality of arms. Therefore, the prosecution and the defense are equal before you. None is superior. And none should come with the assumption that they carry more weight. Therefore, it is your duty to demonstrate, because justice must not only be done, but must be seen to be done. That the scales of justice are balancing, and that you are availing all the parties, and in this case, A1 to A3, the due protection of law. And the law on bail is for their protection. So we urge you to exercise your discretion to give them bail on such terms as you find fit to enable these proceedings to continue when they are free, because they've stayed in custody for the maximum period allowed by law. I yield to my colleague, Spura, for the A3.
Worship, first I join issue with the submissions of Senior Counsel Justin Kwabu, Frederick Mpanga, Martha Karua, Aaron Kiza, and Brian. We contend that Captain Ola Dennis has been on remand exceeding the mandatory 180 days. Your Worship, Section 76 communicates to you and says that what happens when they present Ola to you after the elapse of the 180 days. You're only left with one option: to release Captain Ola. These are the situations where you cannot release Ola. If he has been committed to the High Court, Your Worship, Ola has not yet been committed. Or if it is in the public interest that Ola must not be released, Your Worship, there isn't any evidence that Ola is harmful to the public. Your Worship, then back to Article 126. Exercise of judicial power, which is derived from the people. Clause 2. In adjudicating cases of both civil and criminal nature, Your Worship, these cases of criminal nature, the courts shall subject the law, apply the following principles: that justice shall be done to all, irrespective of their social or economic status. My Lord, Your Worship, Ola is a soldier. We pray that he also enjoys the liberty that is granted, couched in mandatory terms under Section 23(6)(c) of the Constitution. It also further says that justice shall not be delayed. The framers of this Constitution were privy to the fact that criminal prosecution is delayed. That's why they came out with a position that when an accused person is remanded exceeding 180 days, your choice is limited. And Your Worship, I'm appealing and praying for your choice. Maybe push me to the conditions that may be reasonable to grant Ola bail. Ola is a family man. He's a father. Actually, he has children who have to go back to school. He's not sure that they'll go back to school because their father is here. That is Ola. Any other application to keep Ola in lawful custody, we submit that it is very absurd. With that, Your Worship, we join issue with the earlier submissions of the Senior Counsel.
Next, please, Your Worship. We were not aware of the affidavit that was filed.
Chief State,
We were not aware of the affidavit which was filed by the applicants. I don't know where the courteousness went because we have been serving each other. Prosecution has been making it a point to serve the defense each and everything that has been filed. That said, it is in fact of Your Worship that you grant us 1 hour stand over. We look through that affidavit and we make an informed response, but we do not know what it contains. 1 hour, not through it. Because it seems to have a lot. And it would be just fair and just that the prosecution or the respondent looks at it. Also, we haven't been my colleagues have been submitting and they have been keeping authorities to themselves. There are people who are actually singing fairness, but they are actually not responsible. Every authority that has been talked about has not been given to prosecution. We feel that is very unfair in that regard, because we believe they prepared for this application. The fact that they put in an affidavit in support, they were prepared, and therefore we are supposed to prepare all the authority and also grant us an opportunity to prepare our defense in this matter.
What affidavit are you talking about that you want to look at?
There's an affidavit of Prosecution.
Have you been served with the same?
We haven't. And this is what we are asking for, that God gives us 1 hour, only 1 hour, because we operate as a team, the way they do. So we need an hour to look at that affidavit and prepare our response. We are going to give it today, after an hour. That is our prayer.
One, we are opposed to an adjournment for 1 hour. If he was talking of 10 minutes, 15 minutes, it would be okay. Because the only reference to that affidavit is to the date. A1 and A2 have been in custody, from the 20th of November 2024. The contents of the affidavit were not part of this application, because it's an application for bail. So if he wants to look at that paragraph, and I'm saying this because the court is aware that as senior counsel, I am coming from a neighboring country. I flew in today. I hope to go back later. We were in court last time. The prosecution opposed to us coming before the court the next morning. And then after I had left, brought the amended charges. If it's about fairness, let's treat each other fairly. The only thing mattering here is the data. Your Honor may give him 15 minutes to look at the affidavit. 1 hour is too much to ask. We need to get this done.
Just to be on record.
Your Worship, before my colleague responds, the last time we were here, the court adjourned so that we make this application. The person who was present representing the state was Mr. Richard Giribuga. So he's aware, because the court indicated we adjourned for your brother magistrate, because the presiding magistrate was not available, and it was made very clear that the application for mandatory bail would be made because the accused persons had spent more than 1 week. So That was the 21st. We told council. The other one about the authorities. All the authorities which have been cited are versus Uganda, whereby Mr. Billy Vumbuka, representing Uganda, is a party. So it means that by default, the office which sent him argues the cases, that they are not responsible to take stock of these authorities, and armed counsel, aware of what we are coming to do, cannot be taken on to the accused persons. He was aware we were coming to argue just that, and that is why court will note that when my land colleague, Mr. Alvago, asked that we proceed with this application, he did not oppose because he was on notice. So his belated response, perhaps, it is also courteous of counsel to agree when he's overwhelmed and concede that the circumstances are beyond him, so that court proceeds and pronounces itself on the conditions for mandatory bail. So we do not accept the 1 hour because my colleague was aware of what we are coming.
Your Worship, just like a Bible with verses and scriptures, the Bible of justice is the Constitution, which Richard Bidubuka has had for the time he has known the law. And I do not think that an adjournment will have amendments to the articles in the Constitution. Well, the article is speaking in command that these people, F3, ought to be released. Unless Richard Bidubuka is going to come and address court and inform that he's conceding that Richard Dennis Ola goes home. If that is the position, my Lord, I go for them. But if that's not the position, I oppose the adjournment of an hour.
Lastly and briefly, Worship, Mr. Billy Vumbuka Richard stated in live court when he stated that all the authorities that have been cited, he has not been given. Worship, he has an authority which I cited. It's even highlighted for him. So he's lying to court that all the authorities that have been stated have not been given to him, and I pray that he will withdraw that.
Okay.
I think this is very serious. But
No.
I take a notice that you have just submitted it. You have just don't you look so unfair? The rest of my senior colleagues that I can say I don't have any authority. For sure, you are not submitted. You are not given as required. But nonetheless, maybe God can take a decision on that, and then you can guide us on what to do.
Okay, so since the prosecution says that it needs to look at the affidavit, I'm going to give it strictly 10 minutes. Strictly 10 minutes. So court is stood over for 10 minutes. I have had the application made by the defense for the release of the accused persons on mandatory bail as provided for under Article 23(6) of the Constitution on the basis that the accused persons have clocked the 180 days spent on remand before committal. The defense has made detailed submissions that Article 23(6) is a command of the Constitution and that this court does not have the discretion but rather sets the terms for the bail. Prosecution in reply submitted that the charges the accused were charged with under the court-martial ceased and were terminated by the constitutional decision of the Supreme Court. The prosecution submitted that the accused have spent 3 months on remand and not 180 days. The defense in rejoinder submitted that the proceedings of this court are a continuation of the proceedings of the court-martial and thus the days spent on remand should be considered from the time the accused first appeared in the court-martial. The defense has provided a number of authorities to buttress its submissions for grant of mandatory bail under Article 26 of the Constitution. This court is mindful of the provisions of the Constitution of Article 23(6). However, this court also takes cognizance of the Constitution-based guidelines for Courts of Judicature 2022, which commenced on 28 June 2022. The charges that accuse the charge with are capturing nature. Practice Direction number 10.3 of the guidelines provides that for avoidance of doubt, mandatory release on bail for offences triable by the High Court of the Constitution under Article 23(6) of the Constitution shall be granted only by the High Court. This provision allows the jurisdiction of this court to grant the applicants mandatory bail. The fact that this court's jurisdiction is ousted by the Practice Direction number 10.3, this court cannot go ahead to determine whether the days on remand cover the period before the accused were arraigned before this court. I wish to also add that all the authorities cited by the defense are authorities of the High Court, which granted mandatory bail in capital offences, which is well within its jurisdiction as per the bail guidelines. For the above reasons, this court lacks the jurisdiction to grant the applicant's application for mandatory bail. The applicants can apply to the High Court for mandatory bail.
Your Worship, yes, Your Worship, prosecution, Your Worship, now that this court has pronounced itself on that application, we intend to make an application to amend.
Just before, Your Honor, I'm intervening. I'm intervening.
Let me hear what you have to say first. Let me hear.
Your Honor, thank you very much. We have had the ruling and we respect it. And the immediate response, Your Honor, before even the state can come in, the guidance you have cited, the immediate you cited guidance 10, guidance 11 says that once you do that, then 11.3 says that you immediately transfer the file to the High Court. I pray that you abide that guideline and recruit the pardon? Yes. This is the guideline that court is using, so I will want to read it. The procedure for bail, that is the heading. A magistrate's court shall submit the High Court files of persons eligible for mandatory bail. Subsection 2, an application for mandatory bail in the High Court. Yeah, so basically that is subsection 3 of section of sub-guideline 3 of guideline 11. It says that this court submits this application, this file transfers it to the High Court immediately, that the accused person before it are eligible for mandatory bail. And it is our prayer that they are eligible for mandatory bail.
Your Worship, joining issue. Again, citing those guidelines. Because those guidelines, just to put it, to create a link, provide that an application for mandatory bail in a court of this nature will be oral. We have made the oral application. The court has found, as it did, that it does not have jurisdiction. It has not found that the accused persons do not qualify, meaning that the matter now, the issue, is about jurisdiction. Therefore, I'm relying on the same regulation or guideline. 3 reads, a magistrate court shall submit to the High Court files of persons eligible for mandatory bail, and upon receipt, the registrar shall cause the files be registered in the bail register. To that extent, and guided by the first sub-regulation, which provides that applications in the magistrate court are oral. Ours is an oral application now, given the finding of court, for the file to be forwarded to the High Court, which is a command to the registrar to enter it in the bail register so that that application is considered. It appears to be mandatory and not discretionary, so we reckon that once it has been referred to the court, it is bound to abide. I reckon that the response from Mr. Bill Kumbuka will be to affirm the mandatory command so that going forward, the file proceeds to the High Court. Most obliged.
Much obliged, Your Worship. Your Worship, we think that it should be on record of the lower court's record, for when we go to the High Court it might come up, that we specifically contested the selective application of the bail guidelines.
I think that was that is a critique of the ruling which you are not protected to do.
It is fine. Let me put it on
now.
record. It's fine.
That's a wrong
I'll put it on
procedure.
record. Just submit.
Your Worship, we pray that court guides him on decorum, because we are now starting to have a battle.
Make a submission.
Your Worship, it is on record that we filed a bail application in the High Court. Your Worship, the bail guidelines, under specifically guideline number 8, provide for time to dispose of a bail application. Your Worship, it's now 1.5 months, which is over 30 days. Yet in the bail guidelines, they clearly state that a bail application shall be disposed of within 30 days upon its filing. Your Worship, up to now, our bail application we filed has not been fixed or even heard. Now, what we want to be on record is that in this ruling, or in this trial, in this case, there has been selective application of the guidelines that we are using in bail. Because if this court is applying them to say that we must go to the High Court, but the High Court where we are is not fixing our application within 30 days as mandated by the guidelines, we submit that that is a clear and clear selective application of the guidelines. And my learned brother now can come in emphatically to state what he wants to state.
Your Worship, just precisely, and this is in addition to 11.3 that has been quoted by...
Can you use the microphone?
Your Worship, precisely, this is in addition to 11.3 that has been quoted by Councillor Aaron Chiza and Councillor Frederick Ipanga. My Lord, you go to 10.2, I shall read. In the case of a person who has been on remand for 180 days in accordance with Article 236C of the Constitution, the magistrate court shall immediately refer the file to the High Court. My Lord, Your Worship, that's my humble prayer that the file be referred to the High Court.
Again, this is a total interpretation of the provisions that my colleagues are relying on. One, for a magistrate to refer a matter to High Court in case of mandatory bail, that court must have pronounced itself on the fact that the applicant or the accused person has clocked mandatory bail in custody, which is not the case in this regard. It is not a duty of this court to pave way to the release of the applicants, the applicant has a fleet of senior lawyers who can move High Court in this regard. There is no basis for this court to refer this matter to the High Court because they have not, the applicants have not clocked mandatory period in custody. You cannot have the matter in February and then in May you're saying the applicant has clocked mandatory. This is simple mathematics. This court has no jurisdiction. In other words, that application is misplaced. If the applicants wish to make an application before High Court, they can do it on their own initiative, not through the vehicle of court. That court should remove them. And it's not, by the way, it's not the fault of you, Your Worship, that the application which my brother Bayan has been submitting upon has not been fixed. And therefore, I don't want to use a harsh word. I want to use it. But it will be, but you have been giving them a lot of time. But when it comes to me, you give me 1 minute. His application is misplaced. His request is misplaced. They know where to go in case they want the application to be fixed. In summary, Your Worship, I pray that you dismiss that application and we proceed. We proceed with the amendment of the charge sheet and other processes for today, as prosecution has actually addressed for it. So,
you have a very brief rejoinder. Take the guidelines. We cited the requirement of the court to submit the file. Unlike my colleague, Mr. Billy Bumbuka, court did not say that the 180 days period has not been met. But Your Worship, touching from 3, where a magistrate shall submit to the High Court files of persons who are eligible for mandatory bail, and upon receipt of the register shall cause the files to be registered in the bail register. 4 says the register shall list the files submitted under subparagraph 3 for hearing by a judge. 5, which is very important, says, upon disposal of the bail application, disposal, whereby it may be granted or it may not be, the file shall then be returned to the magistrate's court to enable the court to proceed with the committal. It means that once we've applied for bail and the court has found as it has that it's a matter to the High Court, once we have applied, in fact, Regulation 3 doesn't require that we apply. It requires that the court forwards the file. It means that because it is a right of the accused, all other proceedings stop until the matter of mandatory bail is handled. So again, the words in that regulation do not say may. It is shall. As lawyers and advocates who appear at the bar, we are enjoined to be officers of court. We are praying, Your Worship, that you do not allow Mr. Billy Bumbuka to mislead the court and yourself. So, we are therefore saying that the command is that the file be forwarded. We also refer to the same regulations, which is Regulation 10, Sub-Rule 2. A person who has been on remand, which my colleague referred to, more than 180 days, the magistrate shall immediately refer the file. Mr. Billy Bumbuka will have his day in court to make all the healthy submissions. We are saying that this court, per its ruling, now does not have any matter to deal with this one. Let us go. We shall return when that matter is. And perhaps to add, we are certain that when we go away for a bit, it will allow this court some respite. So we pray that we go to the High Court to determine that right which cannot be abrogated from. Then we shall come back when the court has pronounced itself in that regard.
Just one point. We appreciate your ruling, although we were of a different mind. But now that the court has decided to adhere to the guidelines, we are asking the court to be consistent and therefore in line with guideline number 10.2, as urged by my colleague, to immediately refer the file. It would be quite untidy if the court was to adhere to the guideline and then not adhere to the guideline. So for the sake of consistency, predictability, and the appearance of justice being done equally across the board, let this file go to the High Court.
Just a little matter, Your Worship. I just need to record it here. I seek leave.
No.
Your Worship, it is very important. It is going to help this court to reach.
No, let me. Can we have order in court?
In reply to the application, that defense is seeking this court, one, to stop the proceedings before it. Two, refer the matter to High Court for revision. Because they want the High Court to find out whether the proceedings are in line with the procedure. The defense cited a matter which is before the Olympic Body. For whom they allegedly say stopped the proceedings and referred the matter to High Court for revision. What is the law on revision? That is all we should begin from. Revision is provided under Section 48 of the Criminal Procedure Code Act. Cap 122. Those of Uganda. Revision is a preserve of the High Court. And the procedure is that the defense make an application in the High Court. They make the application in the High Court. And then High Court, if deems it necessary or fit, calls for the record from the lower court. It is not anywhere in the law under section 48 and 50 of the Criminal Procedure Code Act that it is provided that the magistrate or the lower court who is in personal conduct of the matter under dispute is by law supposed to A, stop the proceedings, refer the matter, and send the record of proceedings to the High Court. It is not anywhere. The defense are using a completely different procedure altogether. It is the High Court instead which is supposed to call this record if it deems it necessary. And this court is, you're not obliged at any point to stop the proceedings in this matter, because there's nothing wrong on the record. And by the way, there's no provision that defense has to lay out the reasons as to why they are seeking a revision. Whether you have 100 reasons, that is your own. You can only do that when you're seeking a constitutional reflex, not in a revision. So the procedure they adopted is completely, I don't want to say unlawful, but it is irregular. It is misplaced, for want of a better word, for lack of a better word. The defense submitted that your colleague, when faced with such an application, stopped the proceedings and did arrest. Whatever she did is not binding on this honorable court. Whatever the person, I don't know, whatever magistrate, I do not know, because I was not part of that proceeding. Whatever happened there does not bind this court. In any case, it was irregular, because it was supposed to be high court to do that. Merely the fact that someone did something in a manner is not, in a particular way, is not a prerequisite for another person to do it in the same way, especially when you're at the same level. So it is not persuasive in any way, and it's not binding. Because there's no authority to that effect. Prosecution has been on record, and I will insist. Yes, Your Worship, they have been getting a lot of time. Prosecution has been on record, and we shall insist that this is one of the ways of ensuring that this matter is never had. That is not to say that we are pro or we are against the rights of the accused persons, but there is a path this matter is taking, that every time prosecution wants to do something, they are arm twisted. And then we go to another thing. I don't know the purpose of that, but I can see this application is in bad faith. It is in bad faith because they are not supposed to inform you. They should go to the High Court. You should be just informed by High Court letter calling for this record. It is a waste of time, and it is my submission that you dismiss it and we proceed, because our committee papers are ready. We don't want people to lament and say prosecution, the people are in custody, they are not committed. We are ready to proceed in this matter.
Can we have
brief? I'll first say that it's understandable if Sister Billy Bumuka is tired and doesn't recall, but before your learned sister Esther Doi, it was the council. We are aware that it's the court the High Court which caused the fire. But to save time, because of instructions from our clients, we have to make the application. We cannot make the revision application in the High Court when we are before you. So essentially it is an adjournment to make the revision application so that our client can exercise their rights. We do not want to proceed and then the court says there was a problem. So it is an application so that to adjourn, so that we make the revision application, we prepare it and file it. Otherwise, we cannot be in two places at the same time. We are going to seek that application because we don't need permission of court. Thank you. And so we are requesting you that you court bears that in mind because after all, we are going to review what has happened to test the legality, propriety, among others. It's as simple as that. We believe, like I said, that common sense will require that we stop here, the High Court guides us, and we come back. We are not running away from here. We shall come back. We're only saying we want it to be done in an ordinary. We don't want to proceed, yet we are reviewing so that we have a scattered record. That's the simple application. And I'm sure Mr. Bilbumuka knows, because even in that case, he argued a lot, but eventually saw the light. So we're asking him to see light earlier so that you don't waste your time. It normally takes long to see these things, but
Your Honor.
Counsel, please, can court make a decision?
No, I want to rejoin. I'm trying to rejoin, yes.
Briefly.
Your Honor, these are very serious matters. First of all, I think my land brother misunderstood the scope of our application. It's not just a revision application. This is also an application for supervision. And as April said, but he failed to hear, it is also premised on Section 17 of the Judicature Act. Your Honor, logically, it will serve no purpose for us to proceed to the High Court if you proceed with today's proceedings per the prayers of the prosecution. In other words, you will be indirectly telling us that don't go to High Court, because there will be no purpose of going to High Court if you are going to hear committal proceeding. It is both illogical but also legally unconscionable to entertain committal proceedings whose net effect is to frustrate the mandatory bail of accused person. In law, it is called abuse of the process of law. If a magistrate conducts court in such a way that when the prosecution senses that the mandatory bail application has been triggered or is looming, to ensure that there is a committal so that the accused persons do not successfully apply for mandatory bail, that is an abuse of the legal process. It is important that we be mindful of the context of this pre-trial proceeding. The accused here were not arrested in Uganda, were abducted, tortured, illegally detained in military detention for 4 days before they were arraigned before a kangaroo military tribunal. Can I proceed, please?
Maybe God can guide us.
Yes. Counsel Kiza, don't raise the issue.
Yes, I'm not raising issues. So Article 43 of the Constitution, and in the context that I've said, forbids political persecution. What we are seeing here, the use of committal proceedings to stop mandatory bail is a stellar example of political persecution, which is prohibited in absolute terms by Article 43 of the 1995 Constitution. A prosecutor is precluded from using his office to initiate committal proceedings so as to forestall mandatory bail. This is my opinion.
I think
you are not going to zip my mouth.
Just a minute, Your Worship.
Counsel Kiza, let him also.
You see, Counsel, I don't want to take you back to this. Because it's what we call, we need to proceed in a manner that actually represents what we hold out. If you hold out as a lawyer, then present your facts and evidence as a lawyer. You cannot submit in this court and attack the office of the DPP that they are coming up. Yes, I want to be on record. And you say that the office of the DPP prepared the committal papers in a bid to deny the applicant from benefiting from mandatory bail. Did we have an agreement with you? We are performing our role as DPP. So there are some things, yes, there are some things that shouldn't be said here. Otherwise they become too unprofessional, uncourteous.
Let's
Yes, I'm finishing. Subsection 5, clause 5 of Article 120 on the power on the Office of the Director of Public Prosecution reads as follows: that in exercising his or her powers under this article, the Director of Public Prosecution shall have regard to public interest of the administration of justice, and the need to prevent the abuse of the legal process. What are we seeing here, Your Worship? A classic example of the abuse of the legal process by the Office of the Director of Public Prosecution, in his words, claiming that they have come with the committal papers so as, in my opinion, and the opinion shared by the entire legal team and the accused persons here, to frustrate mandatory bail. We implore this honorable court to prevent that abuse of legal process, because it is also tantamount to political persecution prohibited in absolute terms by Article 43 of the Constitution. We cannot run away from the context of this matter. Thank you.
Okay, court is stood over. Accused persons have a right to apply for revision in the High Court. Section 48 gives the High Court the power to call for the proceedings of the lower court to examine them, and it is at that point that the lower court can forward the file for revision purposes. This court cannot hold the criminal proceedings to await the revision proceedings. The court will proceed with the proceedings.
Maybe Doctor will use that one. You can move it and then you hold it.
Your Worship, once again I seek your indulgence, as I did previously, because as has been severally cited, this is a very serious case against us that may lead to our death. Your Worship, this is not the first time I am being charged with treason. This is in fact the third time the DPP has charged me with treason. Last time was we were in this court in 2016. And we stayed in this court for 5 years before they withdrew that charge of treason in 2016. But before that, apart from the other charges of treason, they have charged me with rape, which went to trial, in which the DPP's chief witness, the Director of Criminal Investigations, admitted under oath in the High Court that she had falsified police documents in order to get at me. Under oath. I have also been charged by the same DPP with terrorism, with illegal possession of guns, all of which charges ended in nothing except my suffering In fact, before I was brought and charged here with treason in 2016, I was charged with the same offense in Karamoja, in Moroto, before the DPP realized that he had presented the case in the wrong court. I had spent time in Karamoja, in Moroto prison. So you worship. When I seek your indulgence to pursue our freedom, it's against this background that I seem to be trapped in a country where the prosecutor does everything that leads to my suffering and the suffering of my family. So that's why when he applied for mandatory bail, having spent 6 months, more than 6 months in prison without a committal, it is because we know that they will try to do everything to keep us locked up, tortured, without a legal basis to do so. So, I'm not a lawyer. My lawyers, I believe, have done a good job in seeking our freedom, considering that it's more than 180 days since we were remanded. They have sought for leave, I think they have asked the court to stay in these matters so that we seek a revision of what has been decided. That seems not to have gained your favor. Your worship, it's under those kind of circumstances, prioritizing our freedom and the suffering of our families, but I would like to ask my lawyers, prioritize what needs to be done to seek our freedom. All these charges I have faced, I have never, ever failed to appear in the court for trial. Never for mention, if it is mentioned. Only that it keeps me in the courts rather than doing my job. So your worship, I pray to you this afternoon, is that in the circumstances, I am asking my lawyers to prioritize our freedom, to go and seek that revision, to go and seek that bail where it should be, since we can't get any reliefs from here. I am in prison, and anybody who thinks that being in prison is a cup of tea should try being there. We don't want to stay in prison much longer, but we are in prison. And we will stay in prison as all this is going on. It's our cost with our lives to stay in prison. But allow us to worship that we prioritize what is priority to us, which is seeking, as the law provides, we get relief from the prosecutor's arm and stay in our homes as he does whatever he wants to do. It would be extremely, I think, unfair for me to continue with him, doing what is good for him, without doing what is good for me under the law. So, worship, I ask my legal team to proceed now and do the needful, and that you give us time to come back, pay attention to what is doing.
On behalf of there's another
Just keep it brief.
Your Worship, thank you so much for the opportunity. I don't want to go deep into what I'm going to speak, but I'm not diverting from what my God has stated. To be specific, today I've made 592 days of remand. And this has got to do with my rights. And what we are trying to seek here is simply, under the Constitution, it is on that background, therefore, I have given a strict instruction to my lawyer to strictly pursue the review of this decision on mandatory bail. It is after that that I think other procedures can continue. That's all I request.
Your Honor, with those instructions from our client, on behalf of the team, we seek to withdraw to go and prepare the necessary applications. Thank you.
Your Worship, we are constrained to abide by the instructions of our client, regrettably, so we ask you to allow us to leave because it would appear we no longer have instructions to proceed.
We filed a copy of the amendment, which is dated the 29th day of 2025. We actually served the offense with that copy. We had filed one on it miss, but it had some typo issues, so we made an amendment for which we served the offense. while we are in court. But also, this amendment, the one with the correction was uploaded to Netflix as well. So in the circumstance, we pray that court grants this application to have the charge sheet amended and read the applicants since they are not represented for now.
The amended charges should be read to the accused person.
That's the one that the copy, the one which I did the 29th of May.
Let me look at the